Good morning, ladies and gentlemen. I want to begin by thanking you all for your time and dedication to this case. Most people serve on juries, couple, 2-3 days. You guys have been here for close to a month now, and I want to just express heartfelt thanks for that. It was your time and doing that made sure that Gerhardt got a fair trial. That's what this was about, and we appreciate your time tremendously. You know, we're at the end of the trial here, but I want to actually circle back to the very beginning. The very beginning, jury selection, and remind you guys about that. Multiple days, started off with 200-something jurors, whittled it down, excuse after excuse. People couldn't be here, couldn't be fair, couldn't set aside what they heard, weren't willing to give him a fair shake. And we whittled it down to less and less and less, and we ended up with the 16 of you here. And that wasn't by accident. It wasn't by accident. It's because we saw in you what we were looking for. Jurors that would wait until you heard everything. Jurors that weren't going to convict somebody based off of media reports. Jurors that weren't going to just look at one side of things. Jurors who had logic, reason, and common sense. And most importantly, jurors who had integrity to follow the law on reasonable doubt.
Objection, move to strike. None of this is evidence.
Sustained.
So I'd like to move to strike the entire closing argument up to this point.
Sustain the objection. Sir, please continue.
We went through that process. You guys promised us you would do certain things, and we knew that you would. Now, I'm going to walk you through the evidence and the law today, and it'll be clear that there's reasonable doubt all over this case. All over this case. Before I do, he wants to, whole unwilling, unfaithful, unwilling, untrue. We talked about that. He wants to say unbelievable. I'll add another unword. Undeterred. They're undeterred by the evidence. It doesn't matter what it shows. They're going to spin it in their favor. They came up with a theory and they went to search for facts to support it. They didn't look at the evidence and say, what's the theory that points that out? They came up with a theory and they tried to find any fact they could to fit it. They were undeterred. Undeterred by the DNA. The DNA shows, and I'm going to go through it, she's holding the rock. There's a trillion level DNA on the unstained side. Undeterred. Oh, must be because when she was blocking. Undeterred. The computer, I have to call Inuma again to say that sometimes the computer accesses these files. Undeterred. Still shows that he's looking at this credit card statement from 2018 to show that he has a financial motive, that it's cheaper to kill her than divorce her. Undeterred. Undeterred by the fact the eyewitness picks the wrong person out of the photo lineup. And still, she stared at him, looked into his cold, dark eyes, saw him very clearly. Picks out the wrong person. Undeterred. Undeterred by the bruise on his face. Oh, maybe it's dirt. Maybe it's dirt. Evidence should lead to theories. You don't come up with a theory and then search for evidence to spin it to fit your theory. That's what happened in this case. Ladies and gentlemen, I'm going to go through just some of the law initially, and then we're going to come back, go through all the evidence, and then I'm going to come back on some other parts of the law. So I want to start off first by reminding you, as you know, you took an oath, right? You told us that you would give your word that you would follow the law. You'd follow the law, and we know that you will. I want to start, you can follow along in your instructions if you want. I'm just going to start on page 2. Page 2. I talked to you at the beginning about these 3 principles of justice and fairness that keep our system safe for all of us. Anytime the government waves its accusatory finger at anyone, these principles kick in, and it's a safeguard. It's a safeguard, and that's summarized on page 2. You must presume the defendant is innocent of the charge against him. This presumption remains with the defendant throughout the trial of the case unless and until the prosecution proves the defendant guilty beyond a reasonable doubt. The presumption of innocence is not a mere slogan. Not a mere slogan, but an essential part of the law that is binding upon you. It's binding on you. It places upon the prosecution the duty of proving every element, material element of the offense charge against the defendant beyond a reasonable doubt. Now, I'm a visual learner. I had this chart earlier to help you guys understand how that works. We talked about how the presumption of innocence, you don't start in the middle. You don't start in the middle. It requires that you start here. You start here. It requires that. And then there's a gap. And it's a proof. This has to be filled with proof beyond a reasonable doubt before you even step this way. Before you even step this way. If there's no proof beyond a reasonable doubt, you don't move. You don't move. And let's look what a reasonable doubt is. You must not find a defendant guilty upon mere suspicion or about evidence which only shows that the defendant is probably guilty. Probably guilty is not good enough under the law that you took an oath to uphold. What the law requires, ladies and gentlemen, what is required by law before the defendant can be found guilty is not suspicions, not probabilities, but proof. And think about that word. It's a strong word. We don't pay enough attention to that word. Proof. That's a powerful word. Proof of the defendant's guilt beyond a reasonable doubt. That's the law. Probably not enough. That's the law. Again, visual learner, I have a chart to help you with this. This chart summarizes page 2 in a more simple way. State's burden, it's their burden, right? We talked about they brought the charge. Make no mistake, this is not Arielle Konig versus Gerhardt Konig. This is the state of Hawaii versus Gerhardt Konig with their resources, the police force, their computer experts, their everybody. Their burden, state of Hawaii versus him. This is their burden. If they only provide, if obviously 100% you think is not guilty, not guilty. Probably not guilty, not guilty. Possibly not guilty, not guilty. Maybe not guilty, not guilty. Maybe guilty, not guilty. If you're like maybe, maybe not. If you're left thinking, I don't really know what exactly happened. Maybe, maybe not. If you're here, not guilty. Possibly guilty, probably guilty, not guilty. That's how high the burden is. It's a safeguard against convicting innocent people. This is what you took an oath to uphold. I'm going to circle back to this, but this is what you told us you would apply. Now, I'm going to go through more of the law later, but just very quickly, the law on attempted murder, the elements are on page 14. Page 14. Before we go through the evidence, page 14. Second paragraph. A person commits the offense of attempted murder in the second degree if he intentionally engages in conduct which, under the circumstances as he believes them to be, is a substantial step in a course of conduct intended or known to cause the death of another person. That his intentions was to kill her. That was his intentions all along. That's what they have to show. It goes down, paragraph 1, the elements. The defendant intentionally engaged in conduct. And 2, the conduct under the circumstances as the defendant believed them to be was a substantial step in the course of conduct intended or known to be practically certain by the defendant to cause the death of Arielle Konig. That's what they have to prove, more than maybe, more than possibly, more than probably. That his intention and his knowledge was practically certain he was going to kill her. That's their burden. That's what they have to prove. We'll come back to this. There is an instruction on self-defense. I'm going to talk about that at the end after we go through the evidence. They are the included offenses. I'll walk you through those as well. But let's now look at the evidence, and it'll be clear there is just massive amounts of reasonable doubt. So the first thing, 1 second here. This issue about, was this planned? Okay. Was this planned? This big plan he just went through, this motive, that Gerhardt Konig, you got to know him, that he came up with this plan in late December, that it was going to be cheaper to kill her than divorce her. Was this planned? Let's look at the evidence. Is there a reasonable doubt about that? Let's walk you through that. First of all, she brought up the idea of going on a trip to Oahu. That was her idea. Why would that be the plan? If you're planning on killing somebody, you're an anesthesiologist, you have access to, as they fault him for being a doctor, I'm going to get into that a little later, having these things at home that he uses to save people's lives, that your plan is, let me not stay on Maui, where there's probably 800,000 less people and more secluded areas. Let me sneak syringes through TSA onto an airplane, come to the busiest island there is in Hawaii, 1 million people, go to a place, a trail, a parking lot I've never been to, that I'm not familiar with, and in broad daylight, 4 minutes from a very busy parking lot, I want to try and kill her. That's the plan. That makes absolutely no sense. Logic, reason, common sense. Why would you do that? The life insurance issue. Well, this is the busy parking lot. So I apologize. You saw this, and this was the plan to come here. With all these cars, all these people, he says 99% don't hike or whatever. He didn't know that. He put in here, this is the plan, according to them, that he's going to come to this unknown place with all these people, all these cars, and try to kill his wife instead of just doing it on Maui. That's the plan, according to them. The life insurance issue. Now, this shows two things. I mean, we're going to get into later about how he told her about it that morning, and she learned that morning if something happened to him, she would get $1.5 million. But it's relevant in another way. If in December and January and February, you're planning to kill your wife, why are you going through the process of obtaining $1.5 million on your life for her? That's not the sign of somebody plotting to kill somebody. That's a sign of somebody trying to work on, okay, look, we got to figure this out for our kids, and if something happens, there's, he's not planning to kill her. Now, the birthday card, he writes this morning. It's the only time she got emotional because she knows it was genuine. And I'm going to talk about that more later. He writes this. There isn't an obstacle in this world too hard for me to fight through for you. I would take on anything just to see your smile. You're one of the kindest, most giving and selfless people I know. Selfless people I know. Putting others before yourself. So much love. You're the heart of our family. Fun, fearless, and a terrific mom. The kids and I hit the jackpot with you. He meant that. You don't write a letter like this because if you're planning to kill somebody 2 hours later. There was no plan. There was no plan. The Fed reservation. He made a reservation to go to dinner that night. He's not planning on killing anybody. There was no plan. This is from that day. They're having a great trip. They had gone through some rough times, but they were making some progress, in part because they weren't really talking about it. And that's why she felt comfortable. I'm not saying she was trying to hook up with Miller again. She wanted to travel for work. And that's why she felt comfortable bringing, hey, we've been making progress, but, I got to travel for work, And then she says, my mom can come with me. That's what Gerhardt told you about. So this is them on the trip, right the day before. This so-called big plan. There was no big plan. Now, why are they committed to saying that there was this pre-plan and financial motive? Well, because of course. It makes no sense anyone would have syringes on this hike unless this thing was pre-planned from earlier. So they have to stick to that, even though it makes absolutely no sense. There was no plan. And I got to tell you, I got to tell you, okay, when they get into the fact that in like December or whenever it was, there's a text message where she's like, are you coming home soon? And he's like, this lady just got hurt on a hike and a rock fell on her, so I'm trying to save her life. The fact that they're trying to say that at that time, the light bulb went on in his head and he was like, I got it. I can kill her on a hike with a rock.
Objection.
I mean, that's ridiculous. That's ridiculous.
And a move to strike.
Granted, that's argument.
Racist. Okay. Well, that's what he was pointing out.
Objection again to improper argument.
Sustain.
The idea that he came up with this plan because he was trying to save a patient's life who was hurt with a rock on a hike is ludicrous. So, ladies and gentlemen, as much as they want to avoid it, as much as they try to talk about witnesses and corroborations, the reality is this. What happened on the mountain before the hikers got there, it is essentially she said, he said. The witnesses told you. They didn't see much. One witness only saw one hit. The other didn't see a hit at all. One of them picks out the wrong person in the photo lineup. Okay. Everything before that, they told you they can't say what happened. They don't know how it started. It's she said, he said. Now, by the way, these witnesses who apparently stood there and stared at him for 30 seconds, looking into his deep, cold eyes, they didn't see no syringes on the ground. The one she says she flicked out of his hand that landed right there. They're nurses. They didn't see that because it didn't happen. The point is, ladies and gentlemen, when it's your burden of proof, it's this high, and it is she said, he said. Your she said better not offend logic, reason, and common sense. better not offend be contradicted by the physical evidence, better not be highly motivated, better not have examples of many times where she was deceptive to the police and to you. And all of those are present with her testimony. I'm going to walk you through that. Now, logic, reason, and common sense. The bottom line is Arielle Konig is not reliable. She's not reliable. We talk about credibility. The question is reliability, okay? Logic, reason, and common sense. We don't ask you to leave that at the door. We want you to bring that in here and look at what was said. Let's look at what she said, right? I mean, basically she's saying she wouldn't take the selfie, and then he was like, I'm tired of this shit. Let me throw you off the cliff. And then he tries to stab her with a syringe as he's loading it first, and then he bashes her up to 10 times. That's her story, okay? First of all, the way she describes it makes it sound like he had multiple arms, like an octopus. She says that she's covering, he's on top of her, covering her mouth, and then he has a syringe, and then he's loading he has a vial, and he's loading it, but he's holding her down.
States the evidence.
Can we approach, Your Honor?
Sure, come on.
The inference is, why would you have a vial unless you're trying to load it? He has a syringe in his hand. The other hand, he's holding her mouth. He's down on top of her, doing all of this while she's supposedly kicking and fighting. He only has 2 arms. And in the middle of it, they're having a full conversation. Your mom's not going to be very happy if you do this. You know, the kids aren't going to be, you know, her story makes no sense. Now, logic, reason, and common sense, as we look at her story, and it is a story, okay? We look at her story, if this was a big plan that someone's going to bring a syringe to incapacitate somebody and stab them to make it easier to throw them off the cliff, don't you think they would load the syringe ahead of time? Don't you think they would load that syringe ahead of time? Their story is that he's that's the plan, and in the middle of it, he's like, oh wait, I gotta take out this vial and get it ready. That makes no sense, especially given the fact that it's undisputed he had just gone up the mountain by himself for 10 minutes. If he had it and wanted to use it, he could have loaded it. It makes no sense because it didn't happen. It didn't happen. The other thing, and I'm glad he brought up this thing about plan A, plan B, plan C, because it proves the point I was going to get to. Why in the world, if you bring a syringe to incapacitate someone to make it easier to throw them off the cliff, why would the syringe be plan B? It would be plan A. You would use the syringe first, and then you would throw them off. You wouldn't start the scuffle and make that, start this scuffle and they'd be like, oh wait, now I'm going to stab her with the syringe. That makes no sense. It makes no sense that, that's the plan. He knows if something like that happened, he's a doctor, a toxicology report would show propofol in her thing, in her blood, that this is
not an evidence.
It makes no sense that he would start the scuffle before using a syringe if that was his big plan, because it didn't happen. This idea that she could just flick the syringe out of his hand, he's holding it tight, according to her, he just flicks it. None of that makes any sense. This idea about, well, he hid evidence. The rock is found right there. We don't know exactly where because HPD should have photographed it before they moved it. But why would he get rid of the syringes and leave the rock? None of that makes any sense. And then, of course, we get into him leaving her on the mountain. Leaving her on the mountain. If this is the big plan to use this hike as an opportunity to throw her off and kill her, why would he walk away and leave her there alone thinking he's going back to the car? And they're trying to say, well, all kinds of things about that. But the reality is this. If you think, even though it's not true, if he went off on his own, because if she said, well, it's too high, I'm getting a little scared, and his plan was to kill her, he wouldn't leave her. He would say, okay, you know what, that's fine, but let's just at least go over here and take a selfie and then try to throw her off, right? He wouldn't have left her for that reason. If he was planning to try and throw her, he would have stayed with her. And then her rationale, it went, to get around the idea that undisputable that she clearly said when he got back, she told the detective that he said, oh, you're still here. He was surprised that she was still there. She says, well, he knew I meant I was going to go exploring in that area. Where was there to explore? We heard from witness after witness. It was you either go up or you go down. You don't go off and go exploring. That was her way to try and cover up. That it was clear he left her thinking she was going back to the car, which you wouldn't do if you had a plan to kill somebody by throwing him off the cliff. TSA, we've all been through it. Sharp metal syringe objects, sharp objects, not going to work. Not going to work. Logic, reason, common sense that he has this intent to kill her, but then he lets her crawl away. He lets her go down to the witnesses. Doesn't come after. Doesn't make any sense. Her demeanor. They say, oh, she was very matter of fact and just told it. Ask yourself, if someone's describing what should have been the most horrific thing they've ever been through, bloody murder, someone's trying to stab you with a syringe, a monster's trying to throw you off a cliff, when you're recounting that, you might get a little emotional. Not at all. And she's not just someone who doesn't get emotional, because we saw her get emotional when we showed her the card. When she read the birthday card, she got emotional. I submit to you that was probably guilt. But whatever it was, she knew it was genuine, and she showed an ability to show emotion. That was real. The card was real. You cannot get emotional over a made-up story that didn't happen when you started the fight. Reasonable doubt, logic, reason, and common sense. Now, Arielle's story contradicts the physical evidence. It just does. And this is a huge problem for them. And they try to come up at the last minute with, well, maybe when blocking it, her DNA got on it. But let's talk about that. Because we're talking more than probably, right? You know, he wants to say maybe blocking her DNA got on it. Maybe. Okay. But let's use our logic, reason, and common sense and look at the physical evidence. What does Scott Henderson say? The DNA guy. Generally, yeah, you could expect higher likelihood ratios with the more DNA that's present in a sample. The more DNA present in the sample, you can expect a higher ratio, yes? Generally speaking, yes. The more someone's DNA is on the sample, the higher the number. Higher the number. He then goes on, we learn from him and Amarin, that, very important, the rock, swabbing from the unstained area, there was a stained area that looked like blood, and there was an unstained other side. They swabbed the blood, they tested, of course it's Arielle's blood, I told you that in opening statement, right? The blood side was Arielle. The unstained side, they don't test for blood, they test for human skin cell touch DNA from people holding objects, they told you, okay? The unstained side had a profile for two people, Arielle and Gerhardt. Arielle's number was 1 trillion. His was 290. Let's go back to what Henderson said. The more DNA present on the sample, you can expect a higher ratio. Yes, yes. 1 trillion to 290. The rock was in her hand. The rock was in her hand. The DNA shows that. That blows away her whole story. That she didn't have the rock. The rock was in her hand. Her DNA is all over that. This idea, well, maybe when she was blocking it hit her, that's not going to lead to that much of her DNA on it, more than him.
Objection, speculation.
If he's holding the rock the whole time and she's just blocking, there's going to be more of his DNA than hers. She was holding the rock, and that blows away their entire theory. Scientifically, I asked Amarin, what about scientific evidence, Miss Amarin? And we talked about it. It's unmotivated. Scientific evidence is not trying to get full custody. His retirement. It doesn't lie. It is what it is. And they may say, well, maybe it was there because of this. Again, maybe, maybe not. A huge reasonable doubt. A huge reasonable doubt. She had the rock in her hand. 1 trillion to 290. Now, the other thing about the physical evidence is the injuries. They want to say, we heard about the stellate laceration. I'm going to talk more about it later. But it has one point and it spreads, right? And you heard, she at the end said she doesn't know how many times she was hit. The doctor, Grosjean, said 2, maybe 2, I cannot say how much more. Dr. Arden says 2 to 3, okay? If she was hit 7, 8, 9 times with all his might, it would be way worse. physical evidence doesn't support her version of events. Also, if she's under attack, she's going to be scratching, doing biting, as she says. He has no scratch marks, defensive wounds. There's no bite mark on him, even though she said she bit him. The physical evidence doesn't support her story. And that's a huge problem when it's this she said, he said, and this is your burden. That's a huge problem. Further problematic is the examples of deceptive behavior that we saw through her. Many examples of deceptive behavior that makes her unreliable. We heard about her deleting the text messages to hide it from her husband, to hide the extent of a relationship. That is inherently deceptive to do that. That's inherently deceptive. Now, the affair. Look, I'm not the morality police, okay? I'm not here saying she's an awful person because she had an affair. That's for you to decide, okay?
Objection.
The relevance.
Improper.
Sustained.
And move to strike.
Granted, last argument of morality is stricken from the record.
The relevance of the affair is primarily that she lied about it to the detective. The context is showed in the relationship in January, February, and December, but the relevance is she lied about it to the detective. And that is incredibly important when it is she said, he said, and is proof beyond a reasonable doubt. Let's look at this. This is, he said, well, she describes it to the detective as just some flirty text messages. He says, well, there's nothing in the text messages about sex. Well, she deleted most of them, so we don't really know what's in there. But we do know what we saw. On the trip, the day before he's going to confront her, this is at 11:22 p.m., presumably Hawaii time, or maybe it's California time, whatever, but it's late at night. She's sending this to Jeff Miller. Jeff Miller is sending her this. They have a nickname for Gerhardt Konig, which is that radiology, nuclear, whatever. They call that's I have Konig. They have a code word to let each other know when he's around. She's listening to an audiobook, How to Help My Spouse Heal from My Affair. That's what she's listening to. He says to her, you're engaged and continue an elaborate secret affair instead of coming to me asking to work on our relationship. And her response is, if anything, I learned how stupid it was this time and I know how to make sure it doesn't happen again. That's her response. Okay? Now, to the detective, no affair, just some flirty text messages. To you guys, no affair, just some flirty text messages. You saw 12/1, December 1st, all day long on a Sunday. Good morning, all day long, good night. And that's how she says it to the detective. She was misrepresenting, deceptive, and lying to the detective. Further examples of deceptive behavior is what she does with her primary care doctor and the records. After the fact, she tells her primary care doctor in an email to add, can you add traumatic brain injury? I want to make sure the documentation is consistent between my care at Queens back here in Maui. And that's the important part. Why is that important? Because, number one, she says she doesn't recall reviewing the Queens records. The Queens records doesn't mention traumatic brain injury. Arden told you that, the two don't you think if traumatic brain injury was in her Queens records, they would have asked Grosjean or Carlton Whitney that? It wasn't in there. So this shows she is not just asking the primary care doctor to do this, she's deceiving the primary care doctor into believing that the Queen's record said traumatic brain injury, so the PCP will be like, oh, okay, I'll add it. It's deceptive behavior. It's incredibly misleading. Now, she says she's surprised about the work bag. She's surprised about the work bag. Oh, I didn't know. She knew he had it there. She knew there was syringes and vials in there. She calls her attorney. And then they turn it in and say, oh, surprise, look what I found. She knew it was there. She knew it was there. She lied about that. She lied about her affair. She lied to her primary care doctor. There is I really like quotes. So there's an author, famous author by the name of Samuel Clemens. Most of us know him better as Mark Twain. Mark Twain was giving a speech once to some young people. about the dangers of being untruthful. And what he said was, you ought to be very careful about lying. Because once caught, you can never again be, in the eyes of the good and the pure, what you were before.
Objection to improper argument.
You guys come in here, you give people the benefit of the doubt. They come in here, you say, I'll hear them out. And then they lie about different things. They deceive. In the eyes of the good and pure, of all of you, you can't look at her the same again. It's dangerous. It's dangerous. If she's going to manipulate her PCP doctor, if she's going to be deceptive to the detective, do you think for a second she would hesitate to be that way with you? And then we get into bias, interest, motive. We talked about this. How she knew a divorce was coming. She wanted full custody, how they're using these allegations against him to get full custody, to make it where he can't ever see his kids again, to get half his retirement, to get all of the house, things that she might not get. She knows that. She said to you that their statement is, we want full custody, but if depending on the outcome of the case, that can be revisited later. She knows the ramifications. Now, let's compare that to Dr. Gerhardt Konig. You got to see him. Trust your gut. Trust what you know about people. Is he somebody that is a monster that came up with this plan to stab his wife and throw her off a cliff? Is that the sense you got from him? Or was he a hurt human being struggling with infidelity but trying his best? You know, they talked about his parents, how they moved from South Africa when he was young. He worked really hard to become a doctor. He talks about, oh, she was trying to control everything about her. All of this awful controlling guy. What does she say? Prior to December, you generally describe your marriage as good, right? Yes, sir. This is what Arielle said. You don't describe your marriage as good if somebody is a controlling, coercive, violent person. There's a lot embedded in this. You don't describe it as a good marriage if unless they're a good dad. Look, domestic violence is horrible. There's some awful men out there that use their power, control, financial means to control women in improper ways. This is not him. That's not him. She wouldn't say it was a good marriage if he was like that. His version of events, they fault him for wanting to see her phone and things like that. The audiobook said that's what it takes. This is Arielle. I asked you earlier, you understood the audiobooks you're listening to by these professionals says to give up privacy, give up access, get them to trust again. She says, yes, they're faulting him for the professional advice, what is said. He's not trying to deprive her of her career. He's trying to stop her from seeing the guy that she had an affair with. He was fine with her getting another job. That's a very human thing. Why would you be okay with her going back to work with the guy that she had an affair with? Now, he went into detective mode when he found out about the affair. That's a very human reaction. Very human. He was on the computer looking up Reddit and infidelity and getting some advice. It's not easy when your partner cheats on you. He's struggling with it. They're making some progress in January and February because counseling, she turns it not about the affair, but about other issues. But they're making progress. They're kind of heading in a good direction. They go on this hike. And it makes sense that at that hike, she brings up this issue. Again, not that I want to be with Miller, but hey, I got to travel for work. Okay, I got to travel for work. And this is a detail that you just can't make up, right? He says, then when they're fighting about it, she said, well, my mom can come with me to chaperone. He leaves her because they got into a fight, not because she's afraid of heights. She goes on all kinds of bungee jumping hikes all the time. He comes back and he's like, oh, you're still there. He described to you what happened. He's not saying, oh, he grabbed me and pulled me down. The scuffle started on this mountain trail and they ended up on the ground. Whether they tripped or fell, whatever, he ended up on her. And then he told you how she's grabbing his testicles. And she admits to it. And then I also squeezed his testicles. That's her testimony. It was all happening so fast. You know, we spent a lot of time going through it all. That's not real life. In real life, you don't get hours to be like, okay, and then you did what? Well, why didn't you do this? Well, did you consider that? Did you consider doing this with the rock instead? It was happening in seconds, and he reacted, and he had a reflex, and that's human. That's human. That's human. He reacted. And then he felt horrible about it, and he told you about that. He never wanted to hurt her. Never. He felt terrible about it. He was shocked that he could even do that to her in that moment. He felt horrible. The physical evidence supports his story. The DNA, and I'm going to get into the medical evidence a little more in a second. You have this, which apparently might have been dirt. Undeterred, might have been dirt. You have a cut, you have bruising, right where he said he was hit. Reasonable doubt. Now, the FaceTime with Emil that they call a confession. There's no assurances of reliability. He explained to you what happened in that call. We need to consider it in the context in which it took place and ask ourselves, is this a reliable, thing that happened that we can rely on? Two highly emotional participants in the phone call. One is suicidal. One is thinking his life is over. He's very emotional, calling his son to say goodbye. The other, obviously, not blaming Emil at all, incredibly emotional. His grandma said she was shaking, crying. Two very, very emotional people. Then you look at the environmental factors. He's on the side of a cliff. And they made it a point to get the HPD officer to say, it's very windy over there, notoriously windy. Very, very windy day, according to the police. He's on speakerphone on the side of a cliff talking. And he told you what he did. He was explaining to her, look, she was having this affair. She got hurt. This is her blood. She crawled away or got away. She crawled away. And she said, I tried to kill her. He was telling her that's why he was going to end his life. He wasn't confessing. He was telling her that's why I'm going to end his life. Now, we know this is his testimony. So as you see here today, there's parts of the exact wording and timing of what was said that you don't quite remember exactly verbatim, word for word, correct? He said yes. He cannot tell us exactly word for word what was said. And then we have an example of him making assumptions. He first tells the detective, my dad said he tried to push her off the cliff. That's what he assumed. Not blaming him, that's what he assumed. But later on in the conversation, in the interview, the detective asked you about that, and he clarified, he said, the part about her pushing her off the cliff was what you assumed he meant, not what he actually said, correct? He said, oh yes, correct. So we have an example already of him saying something that he assumed that was inaccurate. He wants to say, it was so clear at the end of his redirect, he said, without a doubt, I know what was said. Do you recall how he had to try 4 times? The first 3? Emil said, yeah, I was confused. I'm kind of confused. And he asked again, yeah, I'm kind of confused. Yeah, I'm kind of confused. And finally, Emil understood what the prosecutor wanted him to say and agreed. I'm not faulting Emil at all, okay? This was a misunderstanding. The second call shows that. Gerhardt calls a second time, and he wasn't saying, why'd you rat me out? He was saying, wait, what? You told Arielle's parents I tried to kill her? Like, I gotta go. And he was gonna go kill himself. This idea that he wasn't giving Arielle the blow-by-blow Emil the blow-by-blow what happened. He was trying to say goodbye to his son. This is not a confession they're making it out to be. I just point out to you, it's not his fault. He's lived with Arielle the last year. He wants to be on Maui. He likes it here. He knows the only way he can stay here is living with her. We talked about her and her actions with the detective and the primary care doctor. He understood what the prosecutor wanted him to say after the 4th try. This was not a confession. Gerhardt's actions after the incident, they want to say it's consciousness of guilt. I say it's it's proof he's human. He went into deep despair. He couldn't believe that he could cause that kind of harm to the person that he loved. And that can coexist with defending himself in the moment, in that reaction. He felt horrible about it. He went into where he was suicidal. What he was saying to Emil on the phone was, I gotta go. I don't want the police to find me, is because he wanted to keep open the option of killing himself, which was turning to be harder than he thought. He didn't want to get caught at that time because he was still thinking about jumping and killing himself. He wasn't evading the police for the purpose of, I don't want to get caught. He wanted to be able to kill himself and have that option. And we'll talk about when he turned himself in later. And that's why he did what he did with the SIM card. He didn't want the police to find him because he was thinking about killing himself. And this idea that in the middle of this suicidal place of being super emotional, that you open your SIM card, you bend a paperclip, open it, and you're going to take the time to put it back where it was instead of just leave it over there. It shows he's human, that he felt terrible about this. He told you how bad he felt. And that can coexist with self-defense. Now, this idea that he was fleeing from the cops, first of all, the officer didn't say we pulled up right next to him. Very clearly they said we pulled up, there was a lane in between us, and he was on the grassy area. This grassy area right here. They said he was here when they got out of the car and he started to flee. And remember? And I said, come on. How the heck was he not going to get in the bushes if that were the case? And then, shockingly, the prosecutor asks him, well, you played D1 football, right, officer? I mean, the fastest man in the world, Usain Bolt, Olympic sprinter from Jamaica, could not get to him from the car if he's trying to get into the bushes. Look, I get it. Officer safety. Look, I'm not faulting them. They came in hot. They're the strategic enforcement detail. Apparently, you got to be 300 pounds to be in it. I get it. They think he has a syringe. Okay? They come in hot. They couple strikes. Don't hit him in the face and arrest him. I'm not faulting them for that. I don't know about this, saying he was trying to flee. Okay, that's not cool. Okay? But I get it. Officer safety. He has an injury. Look at this. It's dried blood and it's bruising. It's the kind of purple bruising that takes place hours later. When you first get an injury, it doesn't bruise. This happened earlier. Dry blood, purple bruising. That takes time to get to that point. A theory in search of facts. I talked to you guys about this. To try and use a computer to manufacture financial motive without telling us last week that sometimes, I'm sorry, how much time is that? Thank you. That sometimes the computer opens files and shows it was accessed. Don't you think that would have been fair to tell you guys that? Instead of leading you to believe that 100% Gerhardt looked at all of these things? Look, make no mistake, he said 80% of it he looked at. He's not hiding that. He's just, when he's up here saying, like, I don't remember at 3 a.m. looking at a 2018 Amex credit card statement that was in my old divorce file. And but undeterred. It shows he had a financial motive. He was looking up how much his divorce costed him in the past. What? He makes a lot of money as a doctor. The search terms: kill, push, shove, syringe. They're looking for the smoking gun. They have had it with his computer. Looking for the smoking gun. What do they find? No smoking gun. Just some search about hikes that you would search if you were truly just going on a hike. Again, maybe, maybe not. They were looking for a smoking gun. They don't find it. So what do? They manufacture a motive, undeterred, theory in search of facts. Oh, no smoking gun. But you know what? It shows he's looking at financial documents. He has a financial motive. It's not fair. I submit to you that whatever they found on that computer, they would find some way to spin it. Whatever they found, they would find some way to spin it. That's not fair. The work bag. And this, I gotta say, he uses these tools and materials to save lives. And they want to fault him for having it? He's a doctor. He talked to you about why he has it on Maui, not on Oahu. He uses these things to save lives, not try and somehow poison his wife. And she knew he would take it from work every day. Now, self-defense First thing you got to decide is whether or not this was deadly force that he used. We know it wasn't. We're going to get into that in a second. But it doesn't matter either way because it's the same rock that she hit him with. So even if it was, even if you say it was deadly force, it was the force that was used against him. So it doesn't matter. It's the same rock. The only thing it does say about it, and this is the part that was incomplete about the duty to retreat. It says, the use of deadly force is not justifiable if the defendant knows he can avoid the necessity of using such force with complete safety by retreating. You only have to retreat if you can do so safely. She's holding on to his testicles, hitting him. And it just talks about being reasonable. He used the same force that she used against him. And they want to say, well, look at the difference. How could it be the same rock? Obviously, if one gets hit cleaner than the other, the same rock can do that. You know, like I could throw something at a baseball at someone's head, and one it hits them in the face, and one it hits them in the arm. It's going to cause obviously it can be depending on how the direction, how hard the landing was. He stopped. He didn't keep going. What amount of force was used? We know. Like I said earlier, we know what Arielle says she doesn't know. I don't know the exact number. They are downplaying what she said because they know it doesn't make sense. They're saying, oh, up to 10 times. So what does that mean? 6, 7, 8, 9? Doesn't mean 2. But now they know that doesn't make sense. She was hit 8, 9 times. So, oh, maybe she meant less. She doesn't know. Grosjean says possibly 2, maybe more. I cannot tell you. Arden says 2 to 3. He says 2. Grosjean talks about, oh, there's rock in there or dirt. He's not a forensic pathologist. He didn't test the material just to show like what it was. You know, her condition after. You saw her walking. She's walking on the hill. Okay. But more importantly, this is her talking after. And I'm going to ask you to do something with me now. If you could help me out here. Either close your eyes or don't look at the screen and just listen to her voice.
Where does he work?
He works for TMG at Maui Memorial Medical Center. TMG is called the
At Maui Memorial.
Memorial, yeah. What TMG's a group of anesthesiologists.
Did you guys drive here today?
Yeah.
Which is your car?
It's a Nissan Rogue.
Do you remember the license plate? If not, that's okay.
It's not our car, we live on Maui.
What color is it? The Nissan.
It's like black or it's gray. It's gray. Somebody just wet my mouth. Like a wet paper towel or something. My mouth filled with works. I don't have any more. Sorry, I know. No, you're an angel. Just trying to stop the bleeding until they get here. Okay. No, I really appreciate it.
What was Gerhardt wearing today?
Wearing like a light gray shirt and
Okay. Does she sound like she has a traumatic brain injury to you? She sounds okay. Look, I'm not saying it wasn't a bad cut. And look, I'm not, nobody wanted her to have that cut. I'm not saying it's not, I'm just saying the level of force he used, you can see. He talks about chunks missing from his scalp. No doctor said that. It was soft tissue. You heard from Dr. Arden, very credible man, that apparently for 14 grand is going to sacrifice his integrity. Obviously, he's not going to do that. He told you the blood is not a good indication of the severity. The blood is not a good indication of severity. No skull fractures, no soft tissue. The tip of her thumb, he said it was just the very tip. And sure, after the first hit, he puts her thumb, it hits hit. Just the tip is fractured. We heard about that. All 3 doctors agree. No substantial risk of death and no serious bodily under the law. All 3 said that. We talked about the stellate laceration. The Glasgow coma score was 15 out of 15. Triage, they waited a few hours outside because she wasn't in that serious of a condition. She had a bad laceration. They sewed it up. She went home the next day. And I don't mean to. He feels terrible that happened. But he wasn't trying to kill her. That's about the amount of force that was used. Now, her eye. Let's look at this photo. The orbital is the most fragile area there is. And he said, very fragile bone. If he hit her with that rock, it would have broke bones. There was a scuffle. They landed on the ground. he's, they're fighting. There's elbows. He's going for the rock. They're fighting for it. There's no doubt her eye got hurt in this thing, but he didn't smash her eye with the rock the way they want you to believe. And then you have his injuries. We talked about that. Now, it's the state's burden to prove to you this was in self-defense. More than probably. That it wasn't under the circumstances, that he reacted as a human when she was doing these things to him and hit him. They have to prove to you it doesn't apply. It was a reflex. It was a reaction. It was a human reflex and reaction to defend himself in the moment. And that can coexist with him feeling terrible about it after. This happened extremely fast, and then he stopped. Now, we talked about the elements of attempted murder. He had no intent to kill her. You see on the bottom, and self-defense applies. They have to disprove those two, self-defense. Then there's something that takes you down to the others, right? The other offenses. If and only if you find any defendant not guilty of attempted murder, then or unable to reach a verdict, unanimous verdict, then you must consider these other included offenses. None of them apply. Self-defense is a defense to all of them. If you think that they didn't disprove self-defense, it goes all the way down. But you work your way down through these things. I'm just going to go through it quickly because I don't have a lot of time. The next one is attempted assault in the first degree. That he took a substantial step in conduct intended to culminate in the commission of assault in the first degree. That he intentionally or knowingly was trying to cause serious bodily injury. Let's look at the definition of serious bodily injury. Serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. The doctors say she didn't have that. He wasn't trying to do that. This doesn't apply. Self-defense, no intent to cause serious bodily injury. You go on to assault in the second degree. Again, serious, no intent to cause serious bodily injury. Self-defense applies to all of this. So you work your way through. Self-defense applies to all of it. Her motive to try and get custody and conviction of any of these things helps her with that. Assault in the third degree.
For improper instruction in the law.
So,
Should be
ladies
substantial.
and gentlemen, we have the instructions of the law. That's the instruction.
Then you get to assault in the third degree, bodily injury or negligent use of a dangerous instrument. Again, self-defense. He wasn't negligent. He was reacting. Reasonable doubt as to every one of these included offenses. So you just work your way down. And then there's something after that called a mutual affray. If this was a mutual affray. Reasonable doubt as to all of these. Now, I'm almost at the end here. I have couple more minutes. I want to end by saying a few things. This is the law. I ask you to use this as a guide to your deliberations. It's not about trying to figure out what happened. Your only goal is to answer the question, is there a reasonable doubt? Did they prove beyond a reasonable doubt this was not self-defense? More than possibly, more than probably. Let that guide your deliberations. It's a way to simplify things. After you talk about any piece of evidence, come back and remind each other, yeah, but does that prove this beyond a reasonable doubt? Let that guide your deliberations. I couldn't help but think last night. When they moved here, the United States, there's these constitutional rights that we all have. They didn't know it at the time, but it was for a moment just like this. When a jury of his peers would come together and follow the law, and follow through on the oath that you took. I want to end with a quote. There was a politician back in the day who was giving a speech, and it was to other politicians, but I think it applies pretty well to jury service. It says, "For those to whom much is given, much is required. And when at some future date, the High Court of History sits in judgment on each of us, recording whether in our brief span of service we fulfilled our responsibilities to the state. Our success or failure will be judged by the answer to 4 questions. First, were we truly men and women of courage? Second, were we truly men and women of judgment? Third, were we truly men and women of integrity? And finally, were we truly men and women of dedication? I ask you to keep those 4 things in mind as you deliberate. Courage to follow the law and do what's right, even if it may not be popular. Judgment to see through some of these ideas that he had a financial motive, that it was cheaper to kill her. Common sense judgment. Dedication to these principles and our Constitution. Dedication to it. Uncompromised dedication to the presumption of innocence and reasonable doubt. Deliberate that way. Uphold your oath. Follow the law. Let this guide you. Enforce the reasonable doubt standard. Follow the law. Do these things. And integrity will be yours. Thank you for your time over the last month. On behalf of Dr. Konig and Manta Dirks, thank you all for your time.
Mark Twain also said, if you tell the truth, you don't have to remember anything. Think back to defendant's testimony. Think back to every time he was asked on cross-examination something that made him look bad, something that made him look like he had a motive, something that was incriminating. Think back to every single time the defendant was asked something like that. And what was his answer? I don't recall. Arielle Konig was able to sit here and testify in front of you for 3 reasons. First, she had her intuition. She saw the defendant looking at her feet on that trail. She saw the defendant tracking her every move. She saw the defendant making sure he saw where she was. And that's what made her feel uneasy. It was her intuition. Second, she fought back. She fought for her life that day. And defense wanted to characterize it as a full conversation, but it was Arielle begging for her life from the defendant. It was Arielle saying, think about the kids. It was Arielle saying, nobody's going to believe this was an accident. This is Arielle trying to reason with somebody who is trying to kill. And the third reason, and the most important reason that Arielle was here to testify to you, is Amanda Morris and Sarah Bucksbaum hearing a call for help, going forward, looking at what they saw, and helping Arielle out. Because the evidence shows that is the only thing that stopped the defendant that day. The only thing that stopped him from continuing to beat Arielle with that rock, from continuing to hit her, from continuing to try and kill her, was Amanda Morris and Sarah Bucksbaum catching him in the act. Defense wants you to think about the life insurance, but you should think about it differently. This is a couple who's going through it in their marriage. Why is it time to renew life insurance? Does that make any sense? No. What the life insurance is, what many of defendant's actions are, is the defendant covering his tracks. The cover-up proves the crime. Defendant had control of the scene when he was done, so he took the evidence with him. He didn't need to take the rock. In fact, he knew that he was seen with the rock. He knew that Amanda and Sarah saw him with the rock. Why take it? And what reason would Arielle have to make up the syringe? None. Think about what Arielle knew. Arielle knew that he had tried to push her. Arielle knew they were right next to a cliff. Arielle knew that people walked up as she was being beaten with that rock. She had enough already. There's no reason to make up the syringe. Defendant's attorney said something These are the facts you just can't make up. And that's what the syringe is in this case. It's a fact you just can't make up. Let's talk about the confession. Emil told you he has no doubt about what the defendant told him. If this was truly a goodbye phone call, if this was truly the defendant telling his son that he was going to commit suicide, what purpose at all would there be to accuse Arielle of having an affair? What purpose does that serve in saying goodbye? That makes no sense. It's just trying to throw dirt on Arielle. That's all it is. It's trying to throw dirt on her. It's trying to make her look bad. It's trying to justify his actions because he knew from the minute he did it, and he knew from the minute he planned it, that it was wrong. And then look at that timeline again. Why? It makes no sense. The defendant was simply trying to say goodbye. It was simply a miscommunication between himself and Emil. If it was a miscommunication, why wasn't it cleared up? Why wouldn't he just tell Emil in that second phone call? Why would in neither of the FaceTime calls the defendant say anything about self-defense? Why wouldn't the defendant say anything about Arielle supposedly attacking him? Because in that moment, he was confessing. In that moment, he had a guilty conscience. And that's why he did what he did. That's why he hid. That's why he tried to run from the police. Think about the list of people that would have to participate in this, what essentially is being alleged as a massive conspiracy to believe what defendant's saying. You have to disbelieve Arielle. You have to disbelieve Emil. You have to disbelieve Amanda. You have to disbelieve Sarah. You have to disbelieve the medical evidence. You have to disbelieve the doctor that the defense hired. And you have to disbelieve what you saw with your own eyes. That's why the defense asked you to close your eyes when they played that video. They wanted you to ignore what you see. That's what this case is about. That's what they're asking you to do. Open your eyes, make a decision based only on the evidence, and the decision is clear. The defendant tried to kill her. The defendant tried 3 different ways, and he still learned out multiple times that day. It is harder to kill than you may imagine. You were told earlier about the defendant's constitutional rights and the founding of this country and how important that is. What are those 3 phrases that this country was founded on? You've probably heard them before. Life, liberty, the pursuit of happiness. And in this case, the defendant, beyond a reasonable doubt, made a conscious choice to try and take Arielle's life. He made a conscious choice to kill her. And that is why the only verdict that is supported by the evidence is that the defendant is guilty as charged. Thank you.
Thank you, Mr. Brennan. The jury in for deliberation. Before I do, to the first 12 jurors, is there anybody here who feels for any reason he cannot participate in deliberations in this case? I see no hands. That means Mr. Kiyama, Ms. Kishi, Ms. Pang, and Ms. Yang, I'm able to let you go, but you're not quite yet done. If one of the other jurors cannot complete deliberations, you may get a call to come back and participate in deliberations. Okay? So, even though you get to go back to your regular lives, and you're not sitting here in the courtroom, those 3 rules still apply. Don't talk to anybody about this case. Keep an open mind. Do not try to learn about this case outside of the courtroom until one of 2 things happens. Number 1, you get a call to come back. Or number 2, you get a call letting you know that deliberations are complete and the case is done. So unless or until you get one of those 2 calls, those 3 rules apply. Don't watch any media, just in case you might have to come back and do further jury service. On behalf of the parties and the rest of the judiciary, thank you very much for your time and your service. I talked about proposed to our jurors early on, you're weathering 2 storms to be here, and all the flexibility and perseverance that you show, that still remains true today as more storms come our way. So again, thank you very much for your dedication, your perseverance, and your service. If I do not have a chance to talk with you later on, I hope you and your families remain safe during this upcoming storm. And again, you have our gratitude. Thank you very much for your service. Feel free to leave. Thank you. One of the jury, as you already know, lunch is going to be brought in for you while you're in the jury deliberation room. I do have a couple of final instructions before I send you in. Your deliberations take place during what I call anchor's hours. So you're allowed to deliberate up until 3:45 today. If you're unable to reach a verdict, I ask you to come back, start again at 9 o'clock. And the reason why if you ask why is it so early, because if there is a verdict, there is time needed to assemble everybody to receive the verdict, and it won't happen before the end of the day. So that's why I release jurors at 3:45. Have you come back at 9 o'clock if you don't reach a verdict today. You will have communication forms along with the verdict forms that will go into the jury deliberation room along with the exhibits. One note about the communication forms. If you do send a communication to the court asking a question, it does take some time before an answer can come back to you. Sometimes it takes up to 45 minutes, sometimes an hour. Okay? If you're waiting for a response, if you can continue on with the deliberations, please do so. A couple of other things. You will not have the opportunity to ask for any additional information that you think is helpful. So you have all of the evidence that's available to make your decision on this case. Also, there are no transcripts available for the testimony of the witnesses. So you have to rely on your collective recollection as to what the testimony may have been. Before I send you in, is McCallum and Ms. Fisher. Will you stand and raise your right hand? Do both of you solemnly swear or affirm that you will take this jury in charge, that you will not communicate with them except by order of this court, that you will allow no one to communicate with them, and that you conduct them into court again whenever so requested by them or by order of the court?
I will. I will.
Thank you. So ladies and gentlemen, I'm going to ask that you take your notebooks, take your jury instruction packets, and all your personal effects as you go into the jury deliberation. All rise. Mr. Garner, anything you want to place on the record before we recess?
Nothing from the state, Your Honor.
So Tom, anything you want to place on the record before we recess?
No, Your Honor.
To all of you, thank you very much for the work that you put in on this case. I remain impressed by the lawyering talents. I haven't been here that long, maybe it's long for some people, but one of the true joys of this job is watching excellent attorneys represent their clients and apply their law. And I am truly privileged to watch that in this case. So thank you very much for excellent lawyering. Until we hear from the jury, court will be recessed.
Thank you, Your Honor.
You are muted.